Good morning, friends. I am talking about important case law in which the behavior of the advocate on court, who is responsible person to be condemned. Friends, the case law is Sanjay Kumar versus State of Bihar and others, 2014. And the honorable justices in this case, who listened the case and decided the case, were Honorable Justice B.S. Chauhan, Justice Justi Chimelswar, and Justice M.Y. Iqbal. Friend, this whole case revolves around Section 165 of the Indian Evidence Act 1872, as well as on the behavior of the advocate on record. For more details to read the complete judgment, you can go through equivalent citation, that is Manu SC 0074 of 2014. Friends, in this case, the court said that in case advocate on record does not appear in the court, his conduct may tantamount to criminal contempt of court. A few advocates have spoiled the working system of the institution of advocate on record who simply lend their signatures for petty amount. The advocate on record is living in a fool's paradise if he thinks that he can play hide and seek with any court of law. These were the overall observations. Now coming to brief facts of the case. The petitioner claimed to have been appointed by the private institute in a fake dental college as a senior lecturer for a period of 1 year and issued 12 post-dated checks for payment of his salary, out of which 9 checks have bounced. The complainant petitioner sent legal notice to the defaulter, but without giving them sufficient to file a reply, he filed a complaint before the magistrate at Danapur, Patna under sections 34, 403, 404, 406, 408, 418, 420, 504 of the Indian Penal Code 1860, and also under section 138 of the Negotiable Instrument Act 1881. Honorable Learned Magistrate Danapur, wide and order, summoned the private respondent for appearance, being prima facie of the view that a case under section 406, 420 of the IPC and under section 138 of the Negotiable Instrument Act was made out by the petitioner. The private respondent challenged the said order by filing the petition before High Court, which was allowed. White impugned judgment and order on various grounds, inter alia that there was an agreement between the parties for service for 1 year, and one of the conditions in the agreement was that the petitioner would not resign from the institution till the completion of 3 years. More so, the petitioner did not give any sufficient time to the accused to respond to the legal notice as he filed the complaint within a close proximity of the date of notice. The High Court, after also concluded that there was nothing on record to show that the notice has ever been served upon the private respondent, and ultimately allowed the said petition on the ground that it was a case of civil nature as it was a matter of recovery of salary. So, friends, aggrieved, the petitioner approached this Honorable Supreme Court, making the averment in the petition that accused person had been running a fake institute and offered the appointment to the petitioner on certain terms, and in spite of working therein, he was not paid the salary. Honorable Supreme Court, going into the pleading of the case, dismissed the appeal and held in this way. It said that in such a fact situation, words fail us to condemn the audacity of the petitioner to tell the highest court of the land to ignore the pleading taken by him. Be that it may be, this court has insisted at the time of first round of hearing of this case that advocate on record Shri Manu Shankar Mishra should remain present in the court at the time of argument and also passed over the matter for his appearance. In the second round, it was informed to Honorable Court that the AOR refused to come to the court. We take a very serious note of the conduct of this ARO, particularly in view of the judgment of this court in Rameshwar Prasad Goyal, Manu SC 0848 of 2013, or second citation you can say 2014, Volume 1, SCC, page 572, wherein this court has categorically held that in case the AORO does not appear in the court, his conduct may tantamount to criminal contempt of court. In fact, a very few AROs have spoiled the working system of the institution of advocate or court, who simply lend their signatures for petty amount. The advocate on record involved is living in a fool's paradise if he thinks that he can play hide and seek with any court of law. So, in such a chaotic situation, any urgy, furgy, half-baked liar under the level of proxy counsel, a phrase not traceable under the Advocate Act 1961 or under the Supreme Court Rules 1966, cannot be allowed to abuse and misuse the process of court under a false impression that he has a right to waste public time without any authority to appear in the court, either from the litigant or from the advocate on record. The ARO with impunity was disdainful towards the order of this court, directing him to appear in the court. He had also not filed any appearance for the counsel who had appeared, nor the said counsel disclosed his name. The court takes serious note of the conduct of the advocate on court, Shri Manu Shankar Mishra, and warns him to behave in an appropriate manner befitting the conduct of an advocate and an advocate on court. Otherwise, this court will not hesitate to take action against him. His conduct will be under close watch of this court. So, with these observations, the petition was dismissed. Friends, this is little bit about all about telling about the behavior of the past advocates. So don't follow these dirty games. Follow the advice of noble advocate, not God, and enjoy your life. God bless you all. See you again.